train station in Enfield. It's train due now in 2 minutes, so I'm just waiting for the train to come along. But there was a WRC hearing there this morning that I was involved in, and it's a good one to understand the benefit of legal advice and to understand the benefit of understanding the law and so on. In the case this morning, I was acting for the employer, and the claimant was representing himself. He was a lay litigant. He was an employee. Now, I act for employers and I act for employees. Regardless, there's no real ideological situation. Whoever pays me, basically, you act for them. But this morning it was a pay-related claim, and I made a preliminary objection that the WRC did not have jurisdiction to hear the case because the two claims that were submitted, according to the WRC complaint form that was put in by the former employee, were out of time. And I made the case, I made a preliminary objection. I sent it in yesterday. I was invited again today by the adjudicator to make my application if I wished. I did. I made a preliminary objection that the WRC simply did not have jurisdiction to hear the case. Now, the employee made the case that the WRC did have jurisdiction. He brought his claim within a certain period of time of the grievance procedure in the workplace, but that is completely immaterial. The fact is, you must bring your claim within 6 months of the alleged breach of the relevant act, and if you don't, you must show reasonable cause and bring it within 12 months. But if you're outside 12 months and if you fail to show reasonable cause, then adjudicator's hands are bound. He simply cannot hear the case. And this morning, in a case which involved a good bit of time on my behalf getting ready for it and so on, because obviously if it went ahead I'd have to deal with a substantive issue and a substantive case and deal with direct examination of my own witnesses, taking direct evidence and cross-examination of the claimant. But the adjudicator basically accepted the argument that I made, and it was fairly clear that the lay litigant employee was unsure or uncertain or simply didn't know the law, and he was obviously very frustrated. I'm sure he's very disappointed. I'm sure he's waited a long time for this, but the fact of the matter is, as the adjudicator said, he must apply the law, and in applying the law he was unable to hear the case because he didn't have jurisdiction. Now, we've been waiting for this case for quite some time. I've put a huge amount of preparation into it, but it only lasted 10 minutes because the adjudicator said he couldn't go ahead and hear the substantive issue without first deciding the preliminary issue, the preliminary objection that I put in, and I would doubt very much that he's going to make any finding other than that he cannot hear the case because it's out of time. So it goes to show you that no matter how enthusiastic or how committed or how exercised you are about a particular issue in the workplace, and no matter how well you prepare, and no matter how much of a submission you make, and no matter what arguments you make, if your claim is out of time, it's out of time. And the legal position is that the WRC do not have jurisdiction to hear cases that are out of time, and the reason for that is because the law is the law and they must apply the law. It's as simple as that. So, as I say, I'm sure it's very, very disappointing for the fella whose case it was, but the fact of the matter is the adjudicator, his hands were tied and my work was done in 10 minutes, thankfully. Now, sometimes adjudicators will hear a preliminary objection and then they'll go ahead and hear the substantive case, and that defeats the purpose of making the preliminary objection, because your time and your resources and so on are dealt with or are taken up with dealing with a substantive issue. But it makes no sense to deal with a substantive case, deal with a substantive issue, if ultimately the adjudicator has to find that you're out of time. So in the interest of efficiency and in the interest of saving resources and so on, an adjudicator really should make a decision on the preliminary objection, the preliminary issue first, and that's what this adjudicator did. in my view, he was a very sensible, very pragmatic adjudicator, and as he said, he believes in calling it as he sees it, etc., etc. That's what he did. So it was a good morning for me, it was a good morning for my client, and it was a learning curve, or learning lesson, as it were, for the lay litigant, because I'm sure, as I say, he was very disappointed not to have his case heard. But the law is the law. Now, sometimes you might say, you might feel some sympathy, etc., for the employee in such a situation, and you might feel some sympathy given that he's a lay litigant and doesn't have legal training and so on. But my job is to do the best I can for my client, and in this case I did the best I could for my client, and it worked out pretty well, and that's what I'm paid to do. So I could make the same arguments in relation if I was on the employee side or whatever, but clearly, you know, knowing the law and having some training and some experience in it is a big help. And time limits are very, very important in any legal claim, whether it's for in relation to employment or whether it's in relation to any other issue like personal injuries or breach of contract or debt collection, etc., etc. So that's it. I'm down here at the train station. It is, I think, the 5th of September 2024. There's the signal cabin there that Jim, my old mate Jim MacDonald, used to occupy his time in service of CIE, and it's not a bad day. I'm finished for the day now. I was expecting to be engaged with that hearing all day, but thankfully the adjudicator accepted the argument and decided that he couldn't go ahead and hear the substantive case without first making a decision on the preliminary issue. So I would imagine in dealing with the preliminary objection, he'll probably find in our favour and decide that he doesn't have jurisdiction to hear the case. That's not a certainty, but I think that's what will happen, and it looks like that's what will happen. So, as I say, it's just worked out very well for me and my client, and that's what you're looking to do. You're looking to give your client the best possible outcome that you can give them, and that's it, and that's my job. So anyway, that's the train gone there to Connolly from Sligo, and there's another train coming now in 16 minutes actually heading to Sligo, so it'll be coming from Connolly. There's the board there.